Welcome, everybody, to another show. We're going to go ahead and talk about some pretty cool stuff, except I'm not going to do the talking today. So I will let you guys know, we're just going to have a 30-minute kind of thing on equity. We're going to talk about just a little intro, and it's going to be kind of on a as needed to know basis. It's going to be about a half hour. So I'm just here to introduce the whole entire thing, just to say hello, you guys, and hola. I don't have everything totally set up with, as you can see, with lighting right now, so all good. But I did want to just come on here and say hello, and I'm going to be doing some different stuff with the recordings on these, because I want to be able to get you guys material, but I can't always get to it every single day because I have other obligations and other things that are going on. And well, you're going to know about them because I'm going to be coming out with some of them. I can't discuss a lot of the things that are happening right now in the private realm because it's still private right now. So what I am going to do is I am going to show you a video here, though. And this video is, let's see. I think this is it. Hello.
Gentlemen, welcome to today.
Well, yes, that was it, but that wasn't supposed to be like that. That was way loud. Sorry, guys. Let me adjust this again and do that. Try that again. Wow. Please don't be that loud. Let me change this up too, so you guys don't see me. I'm going to change it up so you see the screen when I put it up here.
Gentlemen, welcome to today's session of our educational journey into the realm of equity jurisprudence. I am Equity Ed, and it is my pleasure to guide you through a topic that serves as a cornerstone of justice, the origins of equity. Equity, often misunderstood or overlooked, plays a crucial role in ensuring fairness where the rigidity of common law may fall short. Today, we will explore its rich history, the principles that guide it, and its significant impact on modern jurisprudence. Let us begin this enlightening exploration and uncover the pivotal role equity has played in shaping justice. Before we delve into the historical origins, it is essential to define what we mean by equity. In the legal context, equity refers to a set of principles and remedies that seek to achieve fairness and justice, particularly in cases where the law does not provide adequate relief. Unlike common law, which is based on established rules and precedents, equity is concerned with the moral and ethical aspects of justice. It considers the specific circumstances of each case, ensuring that the outcome is fair and just. Equity, therefore, acts as the conscience of the legal system, filling the gaps left by the rigidity of common law. The origins of equity in England. The origins of equity can be traced back to medieval England. During this period, the common law courts were the primary judicial bodies, adjudicating cases based on fixed legal rules. However, these courts often failed to provide remedies for all grievances, particularly in cases where strict legal rules led to unfair outcomes. As a result, individuals seeking justice began to petition the king, the sovereign authority of the land, to intervene and provide equitable relief. In response to these petitions, the king delegated the responsibility to the Lord Chancellor, a high-ranking official who acted as the king's conscience. The Lord Chancellor was tasked with addressing these grievances using principles of fairness and justice rather than strict legal rules. This practice marked the birth of the Court of Chancery, the primary court of equity in England. The Court of Chancery was distinct from common law courts, operating with a greater degree of flexibility and discretion. Slide 4. The role of the Lord Chancellor. The Lord Chancellor, often a cleric or a legal scholar, played a pivotal role in the development of equity. As the head of the Court of Chancery, the Chancellor had the authority to provide equitable relief, such as injunctions, specific performance, and the rectification of contracts. The Chancellor's decisions were guided by principles of fairness and justice, rather than rigid legal precedents. This discretionary power allowed the Chancellor to tailor remedies to the specific circumstances of each case, ensuring that justice was served. The Court of Chancery quickly became known for its flexibility and responsiveness to individual cases. Unlike common law courts, which were bound by the doctrine of precedent, the Court of Chancery could adapt its decisions to new situations. This adaptability was crucial in addressing the evolving needs of society and ensuring that justice was not constrained by outdated legal rules. Not for reading, slide 5, the Maxims of Equity. To ensure consistency and fairness in its decisions, the Court of Chancery developed a set of guiding principles known as the Maxims of Equity. These maxims serve as the foundational rules of equity jurisprudence, providing a framework for equitable decision-making. Some of the most notable maxims include: equity will not suffer a wrong to be without a remedy. This maxim ensures that if a wrong has been committed, the court will provide an appropriate remedy even if the common law does not offer one. Equity follows the law. While equity can provide relief where the law is insufficient, it does not override legal rules. Instead, it works in harmony with the law to achieve just outcomes. He who seeks equity must do equity. This maxim requires that anyone seeking equitable relief must act fairly and justly themselves. It emphasizes the importance of clean hands, meaning that a petitioner must not be guilty of misconduct related to the issue at hand. Equity acts in personam. Unlike common law judgments, which often affect property, equitable remedies typically operate on the person, requiring them to act or refrain from acting in a certain way. These maxims, among others, form the bedrock of equity jurisprudence. They ensure that equity operates consistently and justly, providing a moral and ethical dimension to the legal system. Slide 6, Equity and Common Law, a dual system. For many centuries, England operated under a dual system of law, with common law and equity existing side by side. This arrangement often led to confusion and inconsistency as litigants had to choose between the common law courts and the Court of Chancery. Common law courts were known for their strict adherence to legal rules and the doctrine of precedent, while the Court of Chancery offered a more flexible and discretionary approach. The dual system also meant that different remedies were available in each court. Common law courts could award damages, while the Court of Chancery could issue equitable remedies such as injunctions and specific performance. This separation often led to conflicting judgments and a lack of coherence in the administration of justice. Slide 7, the fusion of law and equity. Recognizing the inefficiencies and inconsistencies of the dual system, England undertook significant legal reforms in the 19th century. The most notable of these reforms was the passage of the Judicature Acts of 1873 and 1875. These acts merged the common law courts and the Court of Chancery into a unified judicial system. The newly established High Court of Justice was empowered to administer both legal and equitable remedies, ensuring a more cohesive and efficient legal system. The fusion of law and equity did not eliminate the distinction between the two. Instead, it allowed for the concurrent application of legal and equitable principles. Judges could now provide a full range of remedies considering both legal rules and principles of fairness. This integration enhanced the flexibility and responsiveness of the legal system, allowing for more comprehensive and just resolutions of disputes. Not for reading, slide 8, the concept of trusts. One of the most significant contributions of equity to the legal system is the concept of trusts. A trust is a legal arrangement in which one party, known as the settlor, transfers property to another party, the trustee, to hold and manage for the benefit of a third party, the beneficiary. Trusts are a prime example of equity's focus on fairness and protection of vulnerable parties. The origins of trusts can be traced back to medieval England, when crusaders would transfer their land to a trusted individual while they were away on pilgrimage. Upon their return, some trustees refused to return the land, leading to disputes that common law courts could not adequately resolve. The Court of Chancery stepped in to enforce these arrangements, recognizing the trustee's obligation to act in the best interests of the beneficiary. Trusts are governed by the fiduciary duty, which requires the trustee to act with loyalty, good faith, and in the best interests of the beneficiaries. This duty is a hallmark of equity, reflecting its emphasis on moral and ethical obligations. Trusts have since evolved into a sophisticated and versatile legal tool used in estate planning, charitable giving, and asset management. Not for reading, Slide 9, Equitable Remedies. Equity's contributions to the legal system extend beyond the concept of trusts. It offers a range of remedies that are distinct from those available at common law. These remedies are designed to address situations where monetary compensation is insufficient or inappropriate. Some of the key equitable remedies include injunctions. An injunction is a court order that either compels a party to do something or restrains them from doing something. Injunctions are particularly useful in preventing ongoing or imminent harm, such as stopping the destruction of property or the publication of defamatory material. Specific performance. This remedy compels a party to perform a specific act, usually the fulfillment of a contractual obligation. Specific performance is often granted in cases involving unique goods or property where monetary damages would not provide an adequate remedy. Rescission. Rescission is the cancellation of a contract, returning the parties to their pre-contractual positions. It is often granted in cases of misrepresentation, mistake, or duress, where the contract was not entered into freely and fairly. Reformation. Reformation allows the court to modify a contract to reflect the true intentions of the parties. This remedy is used when a written contract does not accurately capture the agreement due to a mistake or misrepresentation. These equitable remedies provide a flexible and nuanced approach to justice, allowing courts to tailor their decisions to the specific circumstances of each case. They ensure that justice is not limited to financial compensation, but encompasses a broader range of solutions. Not for reading Slide 10, Equity's global influence. The principles of equity developed in England have had a profound influence on legal systems around the world. As the British Empire expanded, it exported its legal traditions, including equity jurisprudence, to its colonies. Today, countries such as the United States, Canada, Australia, and many others incorporate principles of equity into their legal systems. In the United States, for example, the federal and state courts have the authority to grant equitable remedies alongside legal remedies. The U.S. legal system has also developed its own doctrines and principles of equity while remaining rooted in the English tradition. The flexibility and fairness of equity continue to play a vital role in ensuring justice in diverse legal contexts. Not for reading, Slide 11. Modern-day applications of equity. Equity remains a vital and dynamic aspect of the legal system in the modern era. It continues to address a wide range of issues, from business disputes to personal relationships. Some contemporary applications of equity include intellectual property. Courts often use equitable remedies such as injunctions to protect intellectual property rights. For example, a court may issue an injunction to prevent the unauthorized use of copyrighted material or patented inventions. Consumer protection. Equity plays a crucial role in consumer protection, particularly in cases involving unfair or deceptive business practices. Courts may order businesses to cease harmful practices and provide restitution to affected consumers. Family law. In family law, equity ensures that divorce and child custody arrangements are fair and just. Courts may use equitable principles to divide marital property, determine spousal support, and establish custody arrangements that serve the best interests of the child. Environmental protection. Equity is increasingly relevant in environmental law, where courts may issue injunctions to prevent environmental harm or compel remediation efforts. This application of equity reflects a growing recognition of the need for legal protections for the environment. These examples illustrate the continued relevance and importance of equity in addressing complex and evolving legal challenges. Its focus on fairness and justice ensures that the legal system remains responsive to the needs of society. Not for reading slide 12, the future of equity. As we look to the future, the principles of equity will continue to play a crucial role in the administration of justice. The flexibility and adaptability of equity make it well suited to address new and emerging issues. For instance, the rise of digital technology and the internet has created new legal challenges such as data privacy and cybercrime. Equity provides a framework for addressing these issues in a fair and just manner. Moreover, equity's emphasis on ethical considerations will remain essential in navigating the complexities of modern society. As social norms and values evolve, equity will continue to ensure that the legal system aligns with principles of fairness and justice. Whether in protecting individual rights, promoting social justice, or safeguarding the environment, equity will continue to be a vital force in the pursuit of justice. Not for reading slide 13, conclusion. In conclusion, the origins of equity jurisprudence lie in the pursuit of fairness and justice, addressing the limitations of common law. From its early development in the Court of Chancery to its modern-day applications, equity has consistently served as a crucial component of the legal system. Its maxims, principles, and remedies provide a moral and ethical dimension to justice, ensuring that the law serves not only to regulate conduct, but also to protect and promote fairness. As private individuals and members of society, understanding the principles of equity empowers us to navigate the legal landscape with greater clarity and confidence. Equity reminds us that justice is not solely about strict adherence to rules, but also about ensuring that outcomes are fair and just. Thank you for joining me, Equity Ed, on this journey through the origins and evolution of equity. I hope this exploration has provided valuable insights into the significance of equity in our legal system. Remember, equity is not just a historical concept. It is a living and dynamic force that continues to shape our understanding of justice. Until next time, stay informed, stay fair, and always seek equity in all your endeavors.
All right, you guys, I appreciate you very much. That was today's presentation. We're going to have more stuff like that. I'll have more things that are kind of along the lines, and then we'll have some discussion. I would like to have more interaction, but I want to have Q&As on these things, and then we can present them to you guys. So let's just, we're going to let this kind of go organically. I've got some really cool things that are happening in the evolution of this organization, this group. This is a private organization. This is not an organization for public. I do post some things on here that are relevant to what we're talking about and such, but it's only for you guys to get a better understanding so that you know what we teach privately on the website and in the classes. So I appreciate you guys again for coming out. Thank you for checking us out. I'm very grateful. This is a really short one today, and I really didn't expect it to be this short, but I'll make it longer. And I'm going to have updates for you guys on the case, but the cases that I've talked about, but I can't update anything yet. There's some things that have happened, and you guys know kind of in the classes I've updated you as to what has gone on, what's transpired. But I will keep you posted on more. I thank you guys again for coming out again. I'm sorry it was so short. I'm going to make sure that it does get longer next time. But until then, again, I'm just trying to give you something that will be helpful. We'll get it straightened out. We'll get it fixed, and send you guys much love and much energy. And I appreciate you very much. So with that, I yield.